So now we want to talk about things that makes the international governance of intellectual property standard, which we call the key IP principles. So there are about 4 basic principles of intellectual property, which are 1, territoriality, which means IP laws are territory. So which means IP laws are territorial. They are governed by each country or each territory independently. You cannot say because my IP rights have been granted in South Africa, when I come to Zimbabwe, they should be respected. The laws of Zimbabwe and the laws of South Africa are 2 different sets of laws. Each country has its own laws. And each country's laws must be respected as they are. So IP rights, as long as we have not filed them in that country, they are territorial, or as long as between the 2 countries there is no reciprocal agreements that enables the recognition of IP agreements in one land to be recognized in another territory, IP rights remains territorial. Then there is the concept of national treatment. This concept of national treatment means or implies that if you have reciprocal agreements or have signed international agreements, the rights that you grant to your nationals in terms of IP protection, these rights should also be given to foreigners or to foreign IP owners. That's the principle of national treatment. So which means you cannot favor your nationals in terms of intellectual property protection ahead of foreigners. IP for nationals and IP for foreigners should be treated equally. Then the right of priority, what it simply means that the first to file, the first to register his IP rights, that person has a priority. So if I register for my IP rights at maybe 11:30 p.m. here on 29 December 2022, and someone registers his IP rights at 11:35 p.m. on 29 December, or on the same day that I have registered, my application is treated as the first to file. So if we are registering for the same IP, my application chances of it being granted are very much higher than the one who would register after me. So even as you file for protection in different countries, once you have filed in one country, you now have the right of priority using the same date of filing in all other countries. Then the most favored nation principle. So this is governed by the GATS Agreement 1, Article 1, Article 13, and Article 17. So if country A and country B have agreed on a favorable trade tariffs for trade or regulatory treatment for certain products, that same treatment should be given to all other members of the same protocol. All other members who have signed the same principle or the same protocol should be given also the same treatment. In other words, no country should be given a favorable treatment on a particular issue. All member countries must be treated with the same respect, with the same kind of treatment that is given to one country, as long as all members fall within the same trading agreement. So where do these principles come from? These IP principles are defined or come from the various international IP agreements that are in place. And this is a list of the IP agreements that are there. So we expect you just to familiarize yourself with these various IP agreements. I think we'll touch base on them as we are going to be looking at the various IP tenants independently. So these are the sources of IP laws for most countries. They are also the sources of the principles of intellectual property. The 4 principles of intellectual property. So these are the various IP sources or international agreements that gives us or that define various IP aspects that you should be aware of. So we have treaties for classification of IP. Oh, these are what? And these are the various articles that, or the various articles where the IP principles are defined. For example, the principle of territoriality is defined in the Berne Convention of 1886, where Article 5.2 says that the extent of protection as well as the means of redress afforded to the author to protect his rights shall be governed exclusively by the laws of the country where protection is claimed. So this is what the Berne Convention says on the principle of territoriality. Then the national treatment is alluded in the Paris Convention, Article 2, which said that national treatment for nationals of countries of the Union. So all members of the Paris Convention, when it comes to the principle of national treatment, it said that nationals of any country of the Union shall, as regards the protection of industrial property, enjoy in all other countries of the Union the advantages that their respective law now grant, or may hereafter grant to nationals, or without prejudice to the rights specially provided for by this convention. Consequently, they shall have the same protection as the latter, the same legal remedy against any infringement of their rights, provided that the conditions and formalities imposed upon nationals are complied with. So, again, this national treatment speaks against what the issues of favoritism. And this is what the TRIPS agreement says in terms of what of the national treatment again. Each member shall accord to the nationals of other members treatment no less favorable than it accords to its own nationals. So again, there should not be discrimination between your own nationals and the nationals of other countries when it comes to the protection of what? Of IP. Right of priority. This is what the Paris Convention says in terms of the right of priority. Any person who has duly filed an application for a patent or for the registration of a utility model or industrial design or a trademark in one of the countries of the Union, or his successor in title, shall enjoy for the purpose of filing in other countries a right of priority during the period hereinafter fixed. So once you have filed in one country, like I've previously said, you now have the right of priority in other country. The period of priority referred to above shall be 12 months. So the right of priority is granted for a period of what? 12 months for patent and utility models and 6 months for industrial design and trade secrets. And this is what the GATT agreement says about what the national treatment, so the most favored nation principle. And this is what the TRIPS agreement says about the most favored nation treatment. With regard to the protection of IP, any advantage or favor, privilege or immunity granted by a member state to the nationals of another country shall be accorded immediately and unconditional to the nationals of all other members. Again, there should be no favoritism. So thank you very much. So this was just a brief rundown of the basic principles of intellectual property. Once again, thank you very much for your time.